week 2 of a lecture on 2 recent ABA ethics opinions about judicial conduct. The MPRE includes 1 or more questions in each administration about recent ABA ethics opinions. And the reason for this, I think, is that the opinions themselves flesh out or go into some depth about the specific applications of either the model rules for lawyers or the code of judicial conduct. It seems like the pattern is that they ask about recent ones, and so sometimes one or more, at least, of the questions about the code of judicial conduct are actually scenarios kind of taken from recent ethics opinions about judicial ethics. And so what I plan to do for my students is a few short videos about a few of the big ones here. And so this one I'm going to cover 2 recent ABA formal ethics opinions regarding judicial conduct. And so this is, we're going to start with ABA formal opinion 488. This is from 2009. This is one of the most recent ones, and so it's fair game for upcoming MPRE administrations. And this is about judges' social or close personal relationships with lawyers and parties, and specifically, when does a judge have to disqualify or recuse himself or herself? For my law students, this particular ethics opinion will go hand in hand with my lecture on Rule 2.11 or 2.11 from the Code of Judicial Conduct. So here we go. Judges do not need to disqualify themselves or recuse themselves from a case if a lawyer or a party is an acquaintance. And I should probably phrase it as merely an acquaintance, but I'm using the wording from the ABA's opinion itself. Nor must they disclose acquaintanceships to other lawyers or parties. Now, whether judges must disqualify themselves when a party or lawyer is a friend or shares a close personal relationship with the judge, or should instead take the lesser step of disclosing the friendship or close personal relationship to the other lawyers and parties, depends on the circumstances. So just to clarify what we've said here, judges become pretty familiar with a lot of especially the litigators in their legal community. And so a lot of the lawyers who litigate in that judge's court at all, the judge is going to have met, either by presiding over trials involving that lawyer, or maybe at local bar association events and so forth. So the fact that the judge has met someone, they're an acquaintance, maybe you've chatted with, the judge has chatted with this lawyer or the party on a few occasions or something like that, does not necessitate recusal or self-disqualification by the judge. And in fact, if this is merely someone that you've met on a few occasions and maybe have chatted with, but they're not actually a friend, the judge probably doesn't even need to disclose that on the record. I know that there's a gray area here for people with who we call sometimes acquaintances friends when it's convenient, and we call our friends mere acquaintances when we want to disassociate ourselves from them. But in general, so we don't have a bright line, but if this is someone that the judge really honestly feels is just an acquaintance, the judge doesn't even have to disclose it to the parties. They don't have to say, by the way, I want to notify everyone that I have met attorney so-and-so on several occasions at bar association things, and we've chatted and made small talk or something like that. They don't even have to disclose that. Now, if it's a friend, or maybe a close friend or a best friend or something like that, we have kind of 2 grades of what the judge could do. The judge could either disclose the friendship and say, hey, I just want to let the opposing counsel and the parties know that I have known attorney so-and-so, who's one of the lawyers for this case for many years, and I consider him a friend or her a friend. We've vacationed together a couple of times, or sometimes go to sporting events together and things like that. So if this is someone that the judge that you like, the opinion doesn't define it this way, but is this someone that you would have dinner with alone from time to time, or with the families get together, or that you maybe would go somewhere on an outing with this individual as opposed to running into them at an event, in which case you could just disclose it and say, but I don't think it's going to affect my, my decisions in the case, and ask the other side if they want to waive it, or if they're going to file a motion to disqualify. On the other hand, if the person is really a close friend and the judge is worried that it will look improper, the judge can just recuse herself or recuse himself. Please note that self-disqualification or recusal in any of these situations can be waived, may be waived in accordance and compliance with 2.11c of the Model Code. And if you, just to review, 2.11c it says the judge has to disclose the kind of conflict of interest here, or the friendship with one of the parties or their lawyer on the record, not kind of in a sidebar, but it has to be on the record of the trial, and then has to allow time for this to be discussed and decided upon by the lawyers and the parties outside of the judge's presence, or the judge's agents like clerks and so forth. And then their decision has to be put on the record if the judge is going to proceed. On the other hand, if the judge is in a romantic relationship or desires or is pursuing such a relationship, so the judge has actually asked out one of the lawyers, or has been angling to, trying to get up the nerve, and is infatuated with one of the lawyers or the parties or something like that, the judge should recuse himself or herself from the case if there's a romantic interest. Now, obviously, if this is a secret love, no one will know necessarily unless you tell people. But if you have asked the person out or made romantic overtures that have been maybe politely rebuffed, or the person said, let me think about it, or something like that, and now they're appearing before you in a case, you have to recuse yourself. Okay, next ethics opinion is 485. This is from 2019 as well, and this is about judges performing same-sex marriages. In the background of this is the fact that judges do weddings for people. They perform marriage ceremonies. And so this kind of arose, I think, in response to an actual case and complaint where there was a judge who kind of publicly let it be known that they didn't approve of or agree with gay marriage and or same-sex marriage. And so a same-sex couple asked the judge formally to officiate at their wedding ceremony. The judge declined, and then they litigated over it. And this kind of attracted some media attention and so forth. They complained about the judge, and this came to the attention of the ABA, and then we get this opinion letter. So here we go. A judge for whom performing marriages is a mandatory obligation of judicial office may not decline to perform marriages of same-sex couples. And so in some jurisdictions, judges may have to do weddings when requested. The ABA is contemplating that there could be jurisdictions where, of course, judges have to schedule these things and work it into the judge's schedule, but you could have a jurisdiction where judges have to do marriage requests. It's part of the duties of their office if somebody wants to be married and it gets assigned. And that judge, if you are in one of those jurisdictions, you don't get to decline to do same-sex marriages, regardless of the judge's personal convictions. On the other hand, if this is a jurisdiction where judges have discretion, and so judges can decide if they want to do perform marriages or not, if they can't decline to perform marriages of same-sex couples if they are performing opposite-sex marriages. And so judges basically can't do what the judge I mentioned in the high-profile case was doing, and announced that they'll do same-sex marriages, but that they will do traditional marriages, heterosexual marriages, but not same-sex marriages. The judges, according to the ABA, a judge's refusal to perform same-sex marriages while performing opposite-sex marriages calls into question the judge's integrity and impartiality and reflects bias or prejudice in violation of rules 1.1, 2.2, 2.3a, and 2.3b of the Model Code of Judicial Conduct. Part of the advantage of doing little lectures about the recent ABA ethics opinions is it gives a chance to highlight for my students some provisions of the Judicial Code that I'm not going to do a full lecture about. And there are a number of rules in the Code of Judicial Conduct about judges being impartial and showing integrity and things like that, avoiding the appearance of bias. And this comes up again and again in the Code of Judicial Conduct in different ways. And the ABA is saying that kind of refusing to do same-sex marriages violates those provisions. Now, if you are in a jurisdiction, if you're a judge in a jurisdiction where you don't have to perform marriages, but you have a discretion to do so, then you can, you do have the freedom ethically to say, I don't want to do any marriages. And so, in other words, the ABA is not saying it's an ethical violation for you to just say, I don't like doing weddings, or I don't believe in doing weddings. I think it's a nuisance or a hassle or something like that. Let other judges do it. And so if you have a jurisdiction that allows you to opt out, it is ethical for you to opt out. But what that means is that if you don't want to do same-sex marriages, you have to opt out of doing all marriages. On the other hand, and then here's an exception, if you decline to do marriages as a judge, if you're allowed to, for any members of the public, you may still perform marriages for family and friends. But they add, if you perform marriages for family and friends, you can't refuse to do, decline to perform same-sex marriages for family and friends. In other words, a judge, it's in some jurisdictions, so judges have an opt-out option for performing marriage ceremonies. And so if as a judge you don't like doing it or find it a nuisance, you don't have to do marriages and weddings in those states or those jurisdictions. And if you, and what this ethics opinion says is, if you're going to refuse to do same-sex couple weddings, then you have to refuse to do all of them. But you could refuse to do marriages for members of the general public, like strangers, but still do them for family and friends, so people that the judge actually knows. But even then, if you have defined this parameter, I'm only doing, Judge so-and-so, I'm only doing marriages for family and friends, when they ask, then if you have, let's say, a cousin or niece or nephew or someone like that who wants you to do their same-sex wedding, you can't decline that. So the only way, if you really don't want to do same-sex marriage ceremonies, is to not do any marriage ceremonies as the judge. Okay, that is our mini lecture on 2 of the 2019 ethics opinions about judicial conduct or for judges. There are others, but these were 2 that were pretty discrete and able to cover in one lecture. For my students, I have put up a website here. You can go to the ABA's website and access the Code of Judicial Conduct for free, and there's links to navigate, and you can review the canons, you can review the rules and the associated comments as part of your MPRE prep. And that concludes our lecture.